talk about the case Mohd Radwan Alami. This is under director appointment by the right and resolution topic. Case held in the High Court of Malaya at Kuala Lumpur in the Federal Territory. Plaintiff of this case is Mohd Radwan Alami. The defendants are Ibrahim bin Muhammad Yusuf, Jamil bin Harun, Alami Vegetable Oil Products Sdn Bhd, Muhammad Zaki bin Sohad. Start with the case introduction first. Okay, the first was the plaintiff applied to this court to declare the appointment of the first defendant as a director of the third defendant null and void. Next, the basis of the application stamps that the manner in which the appointment was made is via the Circular Resolution Contravenous Section 3022A of the Companies Act 2016. And then, the defendants argued otherwise, stating that there was a justification to employ the manner in which the resolution was passed and there was no contravention of the Act. And this is contrary to expenses provision under the Constitution of the company, which provides for the appointment of director to be carried out via general meeting. This had attracted the provision contained under Section 302(2) of the Act. Next, the background of the case. Plaintiff Shriyan, a director and a 40% minority shareholder in the third defendant. Second defendant is a director and a 60% majority shareholder of the third defendant. Fourth defendant is a company secretary. The third defendant is a private company limited by shares. These are the founding directors of the third defendant. 2015, relationship between the plaintiff and the second defendant turned sour. Plaintiff and second defendant no longer could cooperate together. The company's financier filed a lawsuit against the third defendant. The deadlock resulted in the company not being able to function and its ordinary course of business. The plaintiff refused to recognize the appointment of the first defendant. The subsequent appointment of the fourth defendant as company secretary was also disputed by the plaintiff. This led to the filing of the application before this court. Case analysis. Section 32 provides for how a company adopts a constitution. Let's see. In this regard, Section 290 of the Act showed how to passing a resolution. Let's see. 2022 provides that directors who are appointed subsequent to the incorporation of the company may be appointed by the ordinary resolution. Section 291 show what ordinary resolution mean under the Act. Let's see. Was contended that a written resolution cannot be passed to remove director. Reference is made to Section 297, which read as follows. For the plaintiff, on the other hand, sought to rely on Section 3022A of the Act. Let's see. Let's go to the finding of the court. Court is compelled to agree with the counsel for the plaintiff that is represent a carve-out of the general provision in Section 32(2). We can refer Qatar Islamic Bank v. Asian Finance Bank Berhad case at below. We can also refer in Luggage Distributors M. Sdn Bhd at page 550. The Court of Appeal had as follows. In Commissioner of Income Tax v. Shahzada Nan and Son at 1996, where Suba and Rao J said, early case of Wong Kim Fat v. Leong and Company Sdn Bhd, Chan Ming Tan held as follows. Let's see. Following passage from the judgment of Lord Asser M.R. in Welton v. Safari 1897 at page 315 state below. In the case Bei Chun Chuan v. Paulo Medical Center Sdn Bhd and ORS 1999, as observed that, let's talk about the deadlock situation. Evident in the case was his inability to convene a meeting due to the breakdown in a relationship between him and the plaintiff. Second defendant holds 60% shares while the plaintiff holds the remaining 40%. Affidavit in reply of the second defendant, he was having difficulty in convening a meeting. It was admitted that the board of directors of the third defendant was in a deadlock. Plaintiff were no longer cooperating and working together. Second defendant decided to appoint the first defendant as an additional director. Second defendant must resort to what is provided under the Act. This court is of the firm view that the solution to the deadlock can be resolved by having recourse to Section 314 of the Act, which provides as follows. From the above discussion, it is patently clear that recourse must be made to Section 314 of the Act by the parties in a situation where a deadlock has occurred at the board level. Section 314 of the Act clearly does not preclude a court form convening a meeting by the attendance of one single shareholder. The onus lies on the parties seeking to move the court to order such a meeting by demonstrating that it is impracticable to do so under the normal provision of the company AOA. The second defendant failed to resort to the above provision of the Act. Parties too had not pursued the other points assiduously as the crux of the issue was on interpretation of the Section 3022A of the Act. Lastly, let's see what's the conclusion of this case. This court is of the view that the resolution passed on the 4/9/2018 was against the constitution of the company, in particular Article 67. As such, the resolution was ineffective by the virtue of the subsection 3022A of the Act. The application in enclosure 1 is therefore allowed. Cost of 10,000 as agreed upon by parties is awarded to the plaintiff. Okay, that's all. Thank you.